vehicle registration number KCL 481K, a Toyota Fielder, grey in color, which according to records maintained at the National Transport and Safety Authority, NTSA, was owned by Miss Olivia Olo, who was the third accused wife. The vehicle was being operated as a taxi, and his driver was a Mr. Jackson Otieno Gombe, who testified as PW38. According to PW38, Mr. Gombe, on the 3rd of September 2018, he received instructions from Olivia, who was the owner of this vehicle, who instructed him to take the vehicle for valuation at Invesco Insurance in Migori. PW38 recalled that accused number 3 directed him to the insurance company offices to get the valuer's telephone number. And after getting in touch with the valuer, he proceeded to Olivia's house to get a copy of the vehicle's logbook. On arrival in Olivia's home, he claims to have found the second, the third, and another person identified as Dicky seated together outside the house. He also recalled that as he was leaving, this Olivia allegedly warned him not to tell anyone about what he had witnessed or what he had seen in that home. In addition, PW38 testified that later the same day, between 4 and 5 p.m., a police officer known as Elvis, who also testified in support of the second accused person's case, who was also one of the bodyguards attached to the first accused, called PW38 and allegedly instructed him to pick the second accused at Oriri at around 6 p.m. and that the second accused would then direct him where to go. He claimed that he knew Elvis as he used to see him with the first and third accused, and he sometimes gave him work, such as picking up customers and relaying information to third accused or his wife. PW38 recalled that he complied with those instructions and proceeded to Oriri, where he found the second accused in the company of 2 unknown men. The 3 of them boarded the vehicle and he drove them to Gracia Hotel, following instructions from the second accused. On arrival at the hotel, the second accused alighted. The second accused was the only person who went to the hotel, while the other 2 men were left standing behind the vehicle. And after about 10 to 20 minutes, the second accused emerged from the hotel, accompanied by a lady who appeared pregnant and another person or another man. According to his further evidence, all the unidentified men who had been in the company of the second accused boarded the vehicle, but the second accused did not. One of these men instructed him to drive to a nearby petrol station and park by the roadside, which he did. Shortly thereafter, the second accused joined them, appearing to have crossed over on foot from Gracia Hotel. And after the second accused engaged in a discussion with the unidentified men, these men boarded the vehicle, one on each side of the rear. Two of them sat on each side of the rear seat of the vehicle, meaning that Sharon and PW9 was sandwiched between these two men, while the other man sat at the front passenger seat. According to PW38, Mr. Gombe, when driving towards Kisumu as directed by one of these unidentified men, he had them questioning Sharon and PW9 about their relationship with the governor, referring to the first accused. He decided not to follow up with the conversation since it did not concern him, and he increased the volume of music in the vehicle. After driving for some time, he claims to have sensed a gush of wind blow into the vehicle, as if the rear door or window had been opened. He recalled that he was at the time driving at a speed of about 60 kilometers per hour. He slowed down, and on asking what was happening, one of the unknown men seated behind him dismissed him, saying, "Wachana na hii fala," and he proceeded with his journey. As he continued driving, he was being directed by one of the unidentified men on the roads to follow. And eventually he was led to a rough road in a forested area with no homes nearby. At some point, he was instructed to stop, switch off the vehicle's engine as well as its lights, and wait. When this is the time that he realized that one man who was previously in the vehicle was no longer there. As when the occupants of this vehicle alighted, he noted that one of them was not there. As only a lady and 3 men alighted. He complied with instructions to wait in the vehicle, and after about 10 to 20 minutes, the 3 men returned, but without the lady. Upon inquiry, he was informed that the lady had been left at their home. He was then directed to drive to Oriri, where the unknown men alighted between 9 and 10 p.m. He thereafter drove to his home in Migori. The prosecution also tendered evidence that in the morning of 4th September 2018, a clinical officer at Migori County Referral Hospital, Mr. Justice Mwindi, received a call from a man who identified himself as Caspal Obiero. Justice knew Caspal before because of his association with the then governor of Migori County. Justice testified as PW22, and he had identified Caspal in court as the third accused. He recalled that after receiving this call from the third accused went to see him in the hospital, accompanied by the second accused. The third accused then informed him that they required his assistance on an issue related to treatment. The second accused took over the conversation and explained that he had been attacked by unknown people the previous night at Kesi, and he had been robbed of money belonging to the first accused. He therefore needed a medical request form issued by a hospital in Kesi, confirming that he had sustained injuries on the previous night as he needed to protect his job. PW22 recalled that upon receiving this request, he contacted his colleague at Kesi Teaching and Referral Hospital. His friend was Mr. Cliff Momanyi, who testified as PW20. PW20 recalled that on this date, that is the 4th of September 2018, at around 10:30 a.m., he was at his place of work when he received a call from his friend, Mr. Mwindi, who requested him to assist his friend, who he identified as Mr. Michael Uamuzi, by issuing him with a medical request form prescribing multiple medical investigations, including chest x-rays, MRI, and CT scans. And although he did not know or examine the said Michael Uamuzi, he fabricated treatment notes and a computer-generated outpatient card purportedly issued at KTRH, that is the Kesi Teaching and Referral Hospital, as a favor to his friend, Mr. Justice. These documents were produced in evidence as exhibits 31, A and B. He recalled that on the same day at around midday, that is PW22, he delivered the medical reports to third accused on the instructions of the second accused. On the same day, that is 4th September, PW23, a police officer at Oriri Police Station, that is Philomen Fidel Isipai, he was at the police station on duty when the second accused went to the police station and reported a case of abduction. According to PW 23, the second accused alleged that on the evening of 3rd September, he was at Gracia Hotel with a lady by the name of Sharon and another man, and that on leaving the hotel, they were abducted in an undisclosed vehicle. That he found himself in Kesi the following morning, having lost 270,000 belonging to the first accused. Upon receiving this report, PW3 instructed the police officer then manning the report office, who testified as PW24, to record the report in the station's occurrence book, which was done. And the extract of that report was produced in evidence as Prosecution Exhibit 35. After this report was recorded, PW23 was made aware of the abduction report that had been made by PW9 the previous evening at Cadell Police Post. And he formed the opinion that the report made by the second accused was suspicious, and the second accused was therefore arrested for further investigations. On the same day, at around 3 p.m., this is now the 4th of September, 2018, Sharon's lifeless body was discovered in a bush near Owade River by Mr. Moses Oditi Oguta, a resident of Owade village. This Moses Oditi, who testified as PW7, was shepherding his cattle towards his home when he stumbled upon Sharon's body. He reported the matter or this discovery at Oyugi's police station. He was escorted by police officers, namely Inspector Mary Mugire, PW18, and PC Midiki, PW19, to the scene where he had left this body, and they found members of the public already gathered. PW18 and PW19 recalled having noted that the body was naked, lying face down in a pool of blood. As investigations, PW18, this is a Mary Mugire, recovered the items she found at the scene and prepared an inventory of the same. The items included items of clothing and open shoes belonging to Sharon, 2 used condoms, 3 sachets of trust condoms, 2 cover packets of trust condoms, and a sachet of some illicit brew. PW18 Mary Inspector Mary Mogire and PC Sami Midiki, after those preliminary investigations, collected the body and took it to Rachuonyo District Hospital mortuary for preservation. On the 8th of September 2018, according to the evidence of PW29, he identified the late Sharon's body to the government pathologist, Dr. Johansen Odwor, PW1, who conducted an autopsy on the body. In his testimony, PW1 recalled that on examining the body, he noted multiple external injuries consisting of 2 slash wounds under the right and left ear, and a total of 7 deep stab wounds, one at Sharon's abdominal area, and the others at several areas of her back. After his examination, he opined that the deceased cause of death was severe hemorrhage due to penetrating force trauma with features of manual strangulation. He documented his findings in a postmortem report, which he produced as Exhibit 1. In the course of his examination, he also noted that the deceased uterus had a dead fetus, which was 28 weeks old. The stab wound to Sharon's abdomen had penetrated to the uterus, gone through the fetus's abdomen, and came out through the umbilicus. He also prepared and signed a postmortem form in respect of the fetus, which he produced as Exhibit 1B. Upon cross-examination by Mr. Kilukumi, Senior Counsel for the first accused, PW1 confirmed that with that kind of injury, the fetus did not have any chance of being born. As reports in both the mainstream and social media platforms started circulating regarding the circumstances in which Sharon and her unborn baby were found dead, and given the public interest the reports had generated, a team of officers from the Directorate of Criminal Investigations headquarters, that is DCI headquarters in Nairobi, was dispatched to Homa Bay to take over investigations into the matter. This team of officers included Chief Inspector Nicholas Konara Olesena, who testified as PW42, the last prosecution witness, and he narrated to the court how investigations in this case were undertaken by the investigating team from DCI headquarters. According to his evidence, together with his co-investigators, they arrived in Homa Bay on the 6th of October 2018 and commenced investigations. They found their second accused already under arrest. In the course of their investigations, they recorded and reviewed statements from persons who have testified as prosecution witnesses. And this included PW21, the health records and information officer at Kesi Teaching and Referral Hospital. This witness, that is PW21, confirmed that the medical records allegedly obtained by the second accused from PW20, purportedly issued by KTRH, did not emanate from the hospital, and they were in fact forgeries. He also recalled that he had obtained the forged medical records, that is PW42, claimed that he obtained these forged medical records at Oriri police station after the second accused had presented them there while making a report about his alleged abduction on the evening of that September 2018. PW42 also recalled having visited Gracia Hotel in the course of their investigations in a bid to obtain CCTV footage about the happenings of the 3rd of September. But he was unable to obtain any, as the device for storage of CCTV images, that is the DVR, was faulty. His investigations also led to recovery of motor vehicle KCL 481K, which had been used in the abduction of the late Sharon and PW9. After this vehicle was identified in court by PW9, he produced it in evidence in support of the prosecution case as PW as Exhibit 17. Further investigations led to analysis of DNA profiles generated from the first accused and baby Sharon, which, according to the government analyst, Mr. John Kimani Mugai, confirmed or revealed that the first accused was the biological father of baby Sharon. He produced a report documenting his findings dated 11th March 2020 as Exhibit 11. In the course of his investigations together with his team, PW42 caused forensic examination of mobile phones, including phones belonging to PW28, an iPhone belonging to the first accused, and Huawei tablet belonging to the deceased. The phones were produced as exhibits in this matter, and the cybercrime forensic report showing text messages and images contained in the aforesaid phones was also produced as Exhibit 51A. Notably, this forensic report showed that the iPhone belonging to the first accused had text messages for only 2 days. That is on the 12th and 13th of September 2018. PW42 also recalled having obtained call data records from two service providers, namely Airtel and Safaricom Limited, in respect of mobile mobile lines used by the late Sharon, PW28, accused 1, accused 2, accused 3, and PW38, together with their M-Pesa records. The reports containing the above details were also produced in evidence by PW42 as exhibits. Another witness, that is PW41, produced, who was the liaison officer with Airtel Limited, produced subscriber details and call data records for the Airtel line, which was acquired by the second accused on the 27th of August. The subscriber details showed that the line was registered under the name of Vincent Abonyo, that who was a PW8. In the course of his investigations, PW42 also recorded a statement from PW39, that is who was the administrator in the car tracking firm known as Cool Point Services, which showed that the car tracking system fixed in motor vehicle registration number KCL 481, which is the vehicle that had been used in the abduction of PW9 and Sharon. Its tracking system was not functional on the 3rd of September 2018 and was only reactivated on the following day, the 4th of September. In her evidence, this was indicative of the fact that the tracking device had either been tampered with or was disabled by failing to record its SIM card with credit, or that it may have been also as a result of low signals. After winding up his investigations, PW42 recommended the prosecution of the 3 accused persons with the offenses charged in this case. At the close of the prosecution case, this court, in a ruling delivered on the 30th of January 2025, determined that the prosecution had established a prima facie case against the 3 accused persons in count 1 and put them on their defense in respect of that count. In respect of count number 2, however, the court found that by virtue of the bond alive principle, which was incorporated into Kenyan law by Section 214 of the Penal Code, baby Sharon, being a fetus which died in its mother's womb, did not fit the description of a person within the meaning of Section 203 of the Penal Code, which is the provision that creates the offense of murder. In the result, this court found that the accused persons did not have a case to answer in count 2, and each of them was accordingly acquitted. or in respect of that count. When the accused persons were placed on their defense, each of them elected to give a sworn statement. The first and the third accused persons did not call additional witnesses, but the second accused called 2 witnesses. In his evidence, the first accused denied having committed the offenses alleged or having conspired with the second and third accused persons or any other person to murder the deceased. He admitted having had an intimate sexual relationship with the deceased from November 2017, and that in February or March 2018, he decided to terminate the relationship, allegedly because he discovered that Sharon had lied to him about having a stationery and boutique business, and that she had also lied about the number of her children and the men in her life. He also testified that when Sharon informed him about her pregnancy in March 2018, although he had decided to terminate their relationship, he was comfortable with the pregnancy, and he continued giving her financial support for her upkeep and antenatal clinics, either directly or through the second accused or through Lawrence Muller, that is PW 28. He, however, admitted that he had grown distant and that the level of his financial support had dwindled. The first accused also supported PW9's testimony that sometimes in August 2018, he communicated with PW9 and gave him an appointment to visit him at his home in Rapogi. That PW9 honored the appointment and went to his home accompanied by PW28. The 3 of them had a meeting, which was also attended by his spouse. He further recalled that in that meeting, PW9 threatened to publish his relationship with Sharon in the media, and that in his response, he told him to go ahead with his plans, as his family and his communication team already knew about it, and the information was in any event in the public domain through social media. Regarding his interactions with PW28, he admitted having had meetings with PW28 in Nairobi and having used him as an intermediary to channel funds to Sharon, in addition to the second accused. He also stated that through PW28, he managed to have the deceased abandon her earlier demands and accepted to have him buy her a plot in rural Homa Bay, in which he would construct and furnish for her a 3-bedroomed house. The first accused, however, admitted that this promise had not been fulfilled at the time Sharon unfortunately met her death. Lastly, the first accused raised an alibi, claiming that on the 3rd of September 2018, when the offense was committed, he was not in Migori as he had already traveled to Nairobi by road on 2nd September 2018. He also claimed that he only got to learn about PW9 and Sharon's abduction on the following day after he was informed by his communications director about it. On his part, the second accused also denied having had any role in the death of Sharon and claimed that the prosecution witnesses had misrepresented facts. He, however, admitted that at the material time, he was working as the first accused's personal assistant, and that after he got to know Sharon and her relationship with the first accused, he became the liaison person between her, the first accused, and PW28. The first accused also used to send him with money to deliver to Sharon, either directly or through PW28. The second accused also admitted that on the 23rd of August 2018, he was in Nairobi together with the first accused on official duty, and that in the evening, he was at Sagret Hotel, from where he sent 22,000 to PW9 through M-Pesa, through the M-Pesa account of PW4. He also admitted that this money was meant to facilitate Sharon's and PW9's travel to Nairobi on the following day. He claimed that the Nairobi meeting, had been scheduled or had been convened at Sharon's request, who had pleaded with him to schedule a meeting between her, PW9, PW28, and the governor, to have the governor resolve differences that had emerged between them. And that when PW9 and Sharon arrived in Nairobi on the 24th of August, he was accompanied by the third accused to meet them at Capital Center. He also recalled that accused number 3 also accompanied him to meet PW28 later during that day. The second accused also admitted having acquired an Airtel line, the line that was referred to by PW9 and PW22, allegedly at the request of the deceased to facilitate easy communication between them. He admitted that the line was not in his name, claiming that he bought it when it was already registered in another person's name. The accused also admitted having called Sharon, PW9 and PW28, telling them or instructing them to henceforth communicate with him only using that line. Regarding the events of that September 2018, the second accused testified that he spent the morning and afternoon performing official duties in Migori County, including preparations for an upcoming official trip to Rwanda. He denied having attended a meeting in Olivia's home in the morning, as alleged by PW38. He, however, admitted having convened a meeting between him, Sharon, and PW9 that evening at the Gracia Hotel. At the hotel, He had discussions with Sharon and also delivered to her 100,000 which was the message he was meant to deliver from the first accused. He also admitted having left the hotel accompanied by Sharon and PW9, but denied that when they got to the parking area, he boarded the vehicle described by PW9, that is the vehicle that was being driven by PW38, together with Sharon and PW9. PW9 and Sharon, according to him, boarded a black vehicle that make Toyota Wish. But he was left behind, and that the hotel's watchman thereafter flagged for him a motorcycle which took him to Rongo, from where he boarded a taxi to his home in Migori. According to the second accused, on the 4th of September 2018, he started his journey to Nairobi by road very early in the morning in order to catch a flight at JKIA for his planned official trip to Rwanda. While near Kesi, he received a call from the Migori County Communications Director asking him to check social media reports which were implicating him in the abduction of Sharon and PW9. He claimed that he was instructed to report to Migori police station. Upon receipt of this information, he aborted his trip to Nairobi, drove to the governor's office in Migori, deposited money for his per diem, but instead of reporting to Migori police station as instructed, for undisclosed reasons, he presented himself at Oriri police station, where he was arrested. He denied having made any abduction report at Oriri police station on the 4th of September 2018 as alleged by PW23, or having had any interaction with PW22 regarding preparation and issuance of forged medical records. He also denied having attended a meeting in Olivia's home on 3rd of September 2018. He maintained that his role in matters pertaining to Sharon and the first accused was limited to that of a messenger looking out for Sharon's well-being. As stated earlier, the second accused called two witnesses, the first one being Mr. Omodi Elvis Okoth, who testified as defense witness 3. This witness admitted that he was at the time serving as one of the first accused bodyguards, and that he had served him in that capacity for 10 years. He also admitted no, not admitted, he denied. He admitted knowing Olivia, that is the third accused wife, but denied having attended a meeting in her home on the morning of that September 2018. He denied that he knew Sharon, claiming that he only learned about her after her death. The second witness, Mr. Patrick Ngamwangi, testified as defense witness 4 and claimed that he was the principal officer in Quantum Motor Assessors and Valuers, a firm dealing with accident assessments and valuation of vehicles. He gave his qualifications as a diploma in automotive engineering from the Kenya Polytechnic and a certificate of proficiency in insurance from the College of Insurance. This witness recalled having received instructions from the law firm of Professor Otieno and Associates seeking expert opinion on the likely consequences of a passenger who was of average height with a lean and athletic body, jumping from a vehicle moving at a speed of between 80 and 100 kilometers per hour, landing on the tarmac. After researching on this brief, he formed his opinion that such a passenger would be expected to sustain extensive and severe injuries, including fractures or death. He documented his opinion in a report which he produced as Defense Exhibit 5B. Upon being cross-examined by Ms. Kekoi for the state, he admitted that his expertise was only limited to motor vehicle assessments, but not medical injuries in the kind of scenario referred to him by the second accused advocates. He also admitted that before preparing his report, he did not conduct any demonstrations, simulations, or reconstructions of the scene using any devices to determine possible outcomes. He instead relied on sketches that he did not produce before the court. The third accused testified as defense witness 5. He also denied having committed the offense as alleged, but he admitted that in the year 2018, he worked at Migori County as a clerical officer, and that Olivia was his second wife and owner of motor vehicle registration number KCL 481K. He claimed that he denied that he was at Olivia's home during the day, claiming that he spent the entire day at his place of work and only went to her home in the evening. He further testified that he met the late Sharon only once, when he accompanied the second accused to a meeting in Homa Bay town, in which the deceased was a participant. He added that he did not have any personal interactions with Sharon and did not even know about her relationship with the first accused until he read about it in the social media. He, however, did not clarify whether this was before or after Sharon's demise. The third accused also denied having contacted PW22 on the 1st September 2018 or requesting him to procure false medical reports for the second accused. He also denied having seen the second accused on that day. Upon cross-examination by Ms. Gekoi for the prosecution, accused 3 Accused 3 confirmed that between 2013 and 2018, he was based at the Migori Governor's office. He also recalled having accompanied the second accused to Capital Center on the 24th of August when he had gone to meet Sharon and PW9. He also confirmed that in his statement to the police, he had admitted that he was at Olivia's wife. He was at Olivia's home, that is his second wife's house, on the 3rd September 2018 at around lunchtime or around midday. In addition, he confirmed that Mr. Gombe, PW38, had been the driver of the subject vehicle, that is KCL 481K, since it was bought by his wife in 2017. After the close of the defense case, Landed Counsel on record for the parties filed lengthy and very elaborate final written submissions, which I have duly considered, together with all the authorities cited. And having carefully considered the evidence adduced by the prosecution and the defense in this case in its entirety, together with the written submissions filed on behalf of all the parties, I find that the only issue arising for my determination is whether the prosecution had proved to the required standard required by the law that the 3 accused persons, whether by themselves or jointly with others not before the court, murdered Sharon Beryl Otieno as alleged. The offense of murder is created under Section 203 of the Penal Code, which stipulates that any person who of malice aforethought causes death of another person by an unlawful act or omission is guilty of murder. A plain reading of the above provision reveals that the offense of murder has 3 essential ingredients which the prosecution must prove beyond any reasonable doubt before it can secure a conviction. The 3 ingredients of this offense have been identified in numerous authorities, which I need not rehash here. It will suffice to cite the authority of Anthony Degwa Gary versus Republic, in which the Court of Appeal held as follows: that the 3 elements of the offense of murder, which must be proved beyond reasonable doubt, were as follows: the death of the deceased and the cause of that death, that the accused committed the unlawful act which caused the death of the deceased, and that the accused had the malice aforethought. It is clear from the provisions of Section 203 and the foregoing authority that the key ingredients of murder are as follows: proof of the deceased, that the death was caused by an unlawful act, and that the accused, with malice aforethought, committed the unlawful act which caused death of the deceased. In general criminal jurisprudence, it is right that for a crime to be committed, there has to be a criminal act accompanied by a guilty mind. As correctly observed by Lord Kenyon in Flower versus Paget, and I quote, "To constitute a crime, there must be, as a general rule, both a guilty mind and a criminal act." In other words, the criminal act, otherwise known as the actus reus, and the guilty mind, or the criminal intent, known as mens rea, must converge for a crime to be committed. For the offense of murder, the actus reus is the unlawful taking of another person's life, while the mens rea is malice aforethought. Malice aforethought is a state of mind that denotes culpability or moral blameworthiness on the part of the person accused of murder. Section 206 of the Penal Code sets out the circumstances in which malice aforethought can be ascertained. And it can be ascertained by proving or establishing any or more of the following circumstances. The first one, an intention to cause the death of or to do grievous harm to any person, whether that person is the person actually killed or not. Knowledge that the act or omission causing the death will probably cause the death or grievous harm of some other person, whether that person is the person actually killed or not. The intent to commit a felony. An intention by the act or omission to facilitate the flight or escape from custody of any person who had committed or attempted to commit a felony. Before addressing the issue isolated above for my determination, I think it is important to point out at the outset that in criminal cases, the prosecution bears the burden of proving the guilt of an accused person beyond any reasonable doubt. This burden is anchored on the cardinal principle of the law of evidence as set out in Section 107(1) of the Evidence Act, which states that, and I quote, "Whoever desires any court to give judgment as to any right or liability dependent on the existence of facts which he asserts must prove that those facts exist." As far as criminal cases are concerned, the prosecution's burden of proof is entrenched in Article 50, Subarticle 2A of the Constitution of Kenya, 2010, which guarantees to every accused person the right to be presumed innocent until the contrary is proved. The standard of proof in criminal cases, which, as I noted earlier, is proof beyond reasonable doubt, was defined by Lord Denning in the case of Miller versus Minister of Pensions in the following terms, and I quote, "Proof beyond reasonable doubt does not mean proof beyond the shadow of a doubt. The law would fail to protect the community if it admitted fanciful possibilities to deflect the course of justice. If the evidence is so strong against a man as to leave only a remote possibility in his favor, which can be dismissed with a sentence, of course it is possible, but not in the least probable. The case is proved beyond reasonable doubt." What that definition means, in my view, is that not every doubt amounts to reasonable doubt as envisaged by the law. From the foregoing, it is clear that reasonable doubt will have been created if, at the conclusion of a trial, the trial court was persuaded to find that there was a real or high probability that the accused person did not commit the offenses charged. In such a case, the prosecution would have failed to prove its case against the accused person, and the accused person would be entitled to an acquittal. Having set out the law on what constitutes the prosecution's burden and standard of proof, I now turn to address my mind to the question whether the prosecution has established in this case the essential elements of the offense of murder against the accused persons. Starting with whether the deceased death occurred and whether or not it was unlawful. From my analysis of the evidence adduced by both the prosecution and the defense, as well as the written submissions filed on behalf of the parties, I find that the death of Sharon was not contested by any of the accused persons. In any event, it was proved through the evidence of PW7, who discovered Sharon's lifeless body near Mauaji Bridge on 4th of September 2018. It was also proved by the evidence of PW18 and PW19, who collected the body from the scene, and PW29, who identified it to the police pathologist, PW1, who conducted the postmortem. There is therefore no doubt that the death of the deceased occurred as alleged. The next question to determine is whether the deceased's death was lawful or unlawful. In this regard, Article 26, subsection 1 of the Constitution is relevant. This provision guarantees to every person the right to life and proceeds to decree at Sub-Article 3 that a person shall not be deprived of life intentionally, except to the extent authorized by the Constitution or other written law. In my view, the import of the above constitutional provision is that there are some homicides which are excusable in law, such as those that are sanctioned by the law. For example, the death penalty, or those resulting from accident or inadvertence. In the case of Gusabizi Wesonga versus Republic, the court gave guidance on what may constitute lawful homicide, and held as follows, and I quote, "Every homicide is presumed to be unlawful, except where circumstances make it excusable or where it has been authorized by the law. For a homicide to be excusable, it must have been caused under justifiable circumstances, for example, in self-defense or property." In the instant case, it is clear from the evidence of PW1, that is the police pathologist, that the deceased or the late Sharon died as a result of multiple and severe injuries in the form of deep stab wounds inflicted on different parts of her body, which were mainly targeted at her vital organs, including her abdomen, which housed her unborn baby. According to the evidence of PW1, her death was severe. The cause of her death was severe hemorrhage due to penetrating force trauma with features of manual strangulation. Given this evidence, which was not contested, it is my finding that the prosecution has proved beyond reasonable doubt that the deceased death was not caused by natural causes, and it was not as a result of an accident or inadvertence. I do not therefore have any hesitation in finding that Sharon's death was unlawful. The singular question now left for my determination is whether the accused persons, with malice aforethought, participated in the unlawful killing of the late Sharon. As correctly submitted by a learned counsel representing each of the accused persons, the prosecution's case in this case is solely based on circumstantial evidence. This is so because none of the 42 witnesses who testified in support of the prosecution case gave direct evidence regarding how the deceased met her untimely death. None of them claimed to have witnessed the unlawful killing of Sharon. This being the case, I think it is important to understand what circumstantial evidence entails and the threshold set by the law for it to sustain a safe conviction. Circumstantial evidence is evidence of surrounding facts and circumstances from which the existence of a fact in issue may reasonably be inferred. It does not directly establish the fact to be proved, but it leads to its proof through a process of logical inference. The Evidence Act, Chapter 80 of the laws of Kenya does not distinguish between direct and circumstantial evidence with respect to admissibility. Both types of evidence are competent and may sustain a conviction if they meet the threshold of proof beyond reasonable doubt. The Supreme Court of Kenya in Republic versus Ahmed Abdul Fathi Mohammed and another comprehensively unpacked what constituted circumstantial evidence and its application. I have reproduced some extract from this evidence, which is a long quote, which I think I need not read in the interest of time. It is settled law that for circumstantial evidence to sustain a conviction, it must consist of credible and cogent evidence, which irresistibly pointed to the conclusion that the accused person and nobody else committed the offense charged. The circumstances should be firmly established in a way that they formed a chain so complete that they were incapable of any other hypothesis other than the guilt of the accused person as charged. The above legal position was also succinctly articulated by the Court of Appeal in the case of Sawe versus Republic, and the court expressed itself as follows, and I quote, "In order to justify a conviction on circumstantial evidence, the inference of guilt, the inculpatory facts must be incompatible with the innocence of the accused and incapable of explanation upon any other reasonable hypothesis than that of his guilt. There must be no other coexisting circumstance weakening the chain of circumstances relied upon. The burden of proving facts that justify the drawing of this inference from the facts to the exclusion of any other reasonable hypothesis of innocence remain with the prosecution. It is a burden which never shifts to the party accused. In denying the offense, each accused person denied having played any role in planning or causing the death of the late Sharon. The first accused, as noted earlier, maintained that he had no motive or reason to cause the death of Sharon, which was demonstrated by the fact that even after terminating his relationship with her, he continued providing her with financial support to ensure her upkeep and general well-being, including her pregnancy to the very end. According to the first accused, a further demonstration that he had no motive to end the life of Sharon was that his intimate relationship with her was at the time an open secret, as it was within the knowledge of members of his family, and it was already in the public domain. The second accused, on the other hand, also asserted that the only role he played in matters concerning Sharon was the role of a messenger to convey money and other communication from the first accused to ensure her welfare. That for this reason, he did not also have any motive to kill her. On his part, the third accused claimed that he barely knew Sharon, as he had only met her once, and he therefore did not have any reason to be involved in her death. In view of the assertions made by the accused persons regarding lack of motive to kill the late Sharon, I find it necessary at this juncture to address the issue of motive and its place in criminal responsibility. Motive, simply put, is the reason for committing an offense. It is provided for under Section 9(3) of the Penal Code as follows. Unless otherwise, and I quote, unless otherwise expressly declared, the motive by which a person is induced to do or to omit to do an act or to form an intention is immaterial so far as regards criminal responsibility. When discussing motive, the Court of Appeal in Limabula versus Republic noted that proof of motive is not essential to prove a crime, but may be relevant, particularly in cases resting on circumstantial evidence. With specific reference to the offense of murder, the same court also held in Robert Onchiri Ogeto versus Republic that proof of motive was not essential to prove malice aforethought. The court held that the prosecution and the court held, and I quote, The prosecution does not have to prove the motive for commission of any crime. Neither is evidence of motive sufficient by itself to prove the commission of a crime by the person who possesses the motive. By virtue of Section 206A of the Penal Code, malice aforethought is deemed to be established by evidence showing an intention to cause death or to do grievous harm. It can be reasonably inferred that when the appellant, now referring to the context in which this case was decided, when the appellant stabbed the deceased with a knife on the chest, he intended to cause death or grievous harm to the deceased. And for that being the case, the court was satisfied that the appellant was properly convicted for the offense of murder, even though motive had not been proved. Regarding the doctrine of common intention, which is the centerpiece or lies at the heart of the prosecution's case, the doctrine is codified in our law under Section 21 of the Penal Code, which provides that when two or more persons form a common intention to prosecute an unlawful purpose in conjunction with another one, in conjunction with one another, and in the prosecution of such purpose, an offense is committed of such a nature that its commission was a probable consequence of the prosecution of that purpose, each of them is deemed to have committed the offense. In Njoroge versus Republic, the Court of Appeal confirmed that the applicability of this doctrine does not require proof of an express agreement. It may be inferred from conduct, presence, and participation of the accused persons before, during, and after commission of a crime. The level of participation, even though minimal, or the role played by each offender, even though insignificant, attracted full criminal responsibility if done in furtherance of the common criminal intention. The above principle, read together with the definition of principal offenders set out in Section 20 of the Penal Code, ensures that criminal liability attached equally to all those who contributed to a joint criminal enterprise. Section 20 of the Penal Code provides that criminal liability applies equally to all persons who actually commit the act constituting the offense, and to persons who aids or abets another person in committing the offense or procures another person to commit an offense. This category of persons are the persons who the law recognizes to be principal offenders. In this case, the first accused admitted the prosecution's claim that he had an intimate sexual relationship with Sharon, as a result of which she became pregnant for him. Although I wholly concur with the first accused's submission that impregnating a consenting young lady of age was not a criminal offense, it is clear from the totality of the evidence adduced in this case that this particular pregnancy formed the basis of subsequent events which culminated into the unlawful death of the deceased. My thorough analysis of the evidence adduced by both the prosecution and the defense shows that the first accused's claim that he had accepted the deceased's pregnancy or that he was comfortable with it, which in his view was demonstrated by the fact that he had continued to give her financial support for her upkeep and to nurture her pregnancy, even though he had terminated their relationship, was, in my considered opinion, actually not sincere and was not true. I make this finding because there is evidence from PW9 and PW30, Sharon's mother, which evidence was not expressly challenged by the first accused. That the first accused had actually exerted pressure on Sharon to abort the pregnancy and had proceeded to give her 30,000 for that purpose, which pressure Sharon refused to succumb to, following advice from her mother. Granted, it may be true that part of the reasons that the first accused decided to terminate his relationship with Sharon was his discovery that she had allegedly lied to him about having a business and her family life. But on the first accused's own admission, he learned about Sharon's pregnancy in March of 2018. And this is the same time he claims to have terminated or decided to terminate his relationship with the late Sharon. In his admission also, and from the account given by PW28 and also PW30, who is Sharon's mother. From that time, the first accused confirms that he became evasive and withdrew his financial support. And according from the account given by PW28, it is apparent that the first accused actually withdrew, withdrew, but did not reduce the financial support he used to give to Sharon, considering that according to PW28, the Sharon was reduced to asking him for assistance for money for her needs. And she was also forced to seek his intervention in identifying a journalist to make her plight public. If indeed the first accused was the magnanimous, considerate, responsible, and caring man he presented himself to be, and he genuinely intended to give Sharon both financial and material support throughout her pregnancy, as he alleged, my take is that he would not have distanced himself, refused to pick up her calls, and withdrew his support from March until July of 2018, when PW1 appeared at the scene with imminent threats of publishing his illicit affair in the mainstream media. It cannot be mere coincidence that the first accused suddenly developed interest in the deceased's well-being and that of her unborn child when Sharon's decision to cause publication of their illicit relationship in the print media was communicated to him by PW9 in the presence of PW28. The first accused was emphatic in his defense that he was not at all concerned about the deceased threat to publicize their love affair in public, because in any event, it was an open secret as it was already in the public domain and members of his family knew about it. And although it may be true that members of his family and some members of staff of the Migori County government knew about the affair, as claimed by PW42, the investigating officer, it cannot be entirely true that all members of the public in the country who held the first accused in high esteem as the political head of the county government of Migori actually knew about it. For instance, Peter, who was a resident of Homa Bay, did not know about this relationship until Sharon herself told him about it. There is also evidence that even though claiming that his relationship with Sharon was already in the public domain, the first accused clearly wanted to contain it within the scope it had reached and prevent it from further spreading to contain it in the scope within which it was, because to illustrate this point, I would refer to the evidence of PW9 relating to what the first accused told him when he was leaving his Rapogi home after the meeting. And this is what PW9 claims that the first accused told him, and I quote, "The governor then escorted us outside the main house. We stood at the staircase. He bade us goodbye and promised to keep in touch after instructing me not to tell anybody about Sharon's pregnancy." This particular aspect of PW9's testimony was not expressly challenged by the first accused. Further, when under cross-examination by counsel for the victim's family, PW28, who the first accused admitted was a truthful witness, recalled having stated in his witness statement that when in a meeting with the second accused outside Tausi Hotel, the second accused had asked him how they could get access to the deceased and PW1's handsets, since they contained evidence that could take the governor to the media. The second accused was not involved in the information in the handsets, as reviewed by the evidence adduced in this case. And the concern he raised about this information getting to the media must have emanated from the first accused. From the above evidence and considering the exorbitant demands that the late Sharon had made to the first accused as a precondition to withholding her intention of going to the media with her story, I am persuaded to agree with the prosecution's submissions that the various amounts of money conveyed from the first accused to the deceased, either through PW28 or the second accused, were not genuinely intended to promote her well-being, but were designed to contain, to manage, and to delay or to make Sharon abandon her intention to publicize her affair with the first accused as a scheme to eliminate her and to silence PW9 was being devised. The same argument applies to the first accused's promise to buy a plot and construct a 3-bedroomed house for Sharon in Homa Bay, since the promise was yet to be fulfilled by the time she met her untimely death. From the totality of the evidence adduced in this case, it is my considered view that the first accused had a very strong motive to unlawfully end Sharon's life, to ensure that his illicit affair with her was not widely publicized through the print media, in order to save himself from possible public embarrassment and reputational harm, and to safeguard his political standing. There is no doubt that the first accused would have been the ultimate beneficiary of such a plot. Sorry, let me go read this again. There is no doubt that the first accused would have been the ultimate beneficiary of such a plot, as he was likely to suffer if the deceased actualized her threat of publishing them in the media her story regarding their illicit love affair. In the premises, I am persuaded to agree. I'm persuaded to agree that in order to eradicate the imminent threat of having the possibility of having his name or reputation dragged through the mud by publication in the mainstream media of this relationship with Sharon, the first accused instigated a scheme to eliminate Sharon and using his influence as the governor of Migori County, he enlisted the services of his trusted aides, the second accused, who was his personal assistant, and the third accused, who worked as a clerical officer in the county government of Migori. This must be why, in my view, the first accused insisted to PW9 and to PW28 that all matters concerning Sharon's pregnancy should be directed to the second accused. And he consistently used the second accused as his intermediary with Sharon, PW9 and PW28. From the evidence, it is clear that the second accused embraced the role he had been assigned by the first accused. Because besides delivering money and other messages to Sharon, and sometimes to PW28 on behalf of the first accused, he also instructed PW9 and PW28 to keep off all matters related to Sharon, as he would henceforth deal with them. This finding is also strengthened by the evidence also adduced by the prosecution, which demonstrate or which shows that accused number 2 also embarked on activities meant to disguise or conceal his communication with Sharon, PW9 and PW22, as well as M-Pesa transactions. And this happened prior to the commission of the offense. This evidence is demonstrated by
Friday, the biggest voices on television gather to bring you the most talked about weekly topics.
No, it stops the reasoning, and the reason why I do not like it.
This is The Trendsetters, a bold, unfiltered panel bringing the heat on matters politics, lifestyle, pop culture, and so much more. It's witty, it's smart, it's chaotic, it's edgy, and even more captivating.
Gikomba should exist as a Kenyan, promoting Kenyan textile industry and not the Mutumba industry.
If it's trending, we're on it. If it's controversial, we are already arguing about it. Don't just watch it. Join the conversation. Trendsetters every Friday from 8 p.m. exclusively on NTV.
What do you want me to do?
Well, that's up to you. Just remember that I'm always on your side. She's the one who killed your brother.
I want to ask you something. About Mehmet. You told him that you were in love with me. Is that true?
What's going on? What are you doing? You're drawing their attention, Sema. What's with the anxious answers and all that?
Did you and Mehmet plan everything that he did to me, huh? How can you do this to me? I'm your sister. I could have died in the hands of that maniac.
From signature brews to world-class cocktails, our barista and mixology courses turn your passion into skills employers look for every single day. Amboseli Institute, where intentionality builds impact and credibility that gets you hired.
When we talk about hypertension, what exactly do we mean? And then we'll keep going deeper into that threshold of when you should be worried.
Basically, it's when your blood pressure is elevated above the normal. And by the time they're finding out, you already have organ effects of the body, and the body is failing in one way or another, and it's a bit too late.
Oh, I had a headache, I had vision changes, I felt pain here. But you see, retrospective, because you always dismiss these pain symptoms, because anything that's not normal is abnormal, right? If it's out of routine, you need to get it checked.
And for us, it's just for you to remember that it's 1 in 4 adults, right, who have this. It's a communication thing, it's a trust issue, but whatever the case, the message today is clear. Please get checked. Tell the loved ones around you to get checked.
Join me, Janet Mbogwa, on Healthy Nation every Sunday at 6 p.m. on NTV. Healthy Nation. Your health, your wealth.
Trade is changing, supply chains are evolving, and the future belongs to those who are ready. This July, East Africa's logistics, warehousing, and e-commerce stakeholders will come together for one powerful event. Welcome to the East Africa's Logistics, Warehousing, and E-commerce Conference and Expo 2026. On 30th and 31st July at Iconic Plaza Hotel, Nairobi, discover game-changing innovations, connect with industry leaders, government decision makers, investors, and regional trade partners. Whether you're looking to grow your business, make deals, gain market insights, launch new solutions, build strategic partnerships, or stay ahead of the competition, this is where opportunities begin. Powering the future of regional trade, supply chains, and digital commerce. Don't just witness the future, be part of it. Register today. Call Vera on 0723 562 991 or Alice 0724 168 167 or John 0722 970307. Email vowade@ke.nationmedia.com.
I'm talking to somebody here. You are going to begin small. You may begin insignificant. You may begin by picking behind other people. But please just keep on going, because there's a double harvest that comes. Listen to my next one. That comes out of perseverance. Time is on your side. The Lord is watching over your steps. When you get to strategic partnership, there's a synergy. Because one can chase 1,000. But two can chase how many? 10,000. Kwa mafuta ya mwaka huu, nira imeondolewa, mizigo imeondolewa, viambaza vimeondolewa, kizuizi kimeondolewa. Somebody say amen.
He acquired this line for exclusive communication between him, the deceased PW9 and PW8. But he continued using his regular Safaricom and Airtel lines to communicate with every other person. The second accused claim that he acquired this line when it was already registered in PW8's name cannot be true, because according to PW26, in order to acquire an Airtel line, the party seeking that acquisition had to register the SIM card using an identity card. PW26 also recalled that the person who registered their forwarded line, who he could not remember, actually registered this line using an identity card issued in the name of Vincent Abonyo. PW26 evidence was not shaken in cross-examination, by the second accused. And I am convinced that his evidence represented the factual position regarding how the second accused acquired that Airtel line. The fact that drawing from the foregoing or drawing from that evidence, I am satisfied that the second accused fraudulently acquired the Airtel line for the sole objective of concealing his communication with the deceased, PW9 and PW28, so that any such communication would in future not be traced to him. His inconsistent explanations to PW9 and PW28 regarding the reason he had procured the line demonstrates lack of truthfulness and undermines the credibility of his testimony. More importantly, the fact that the line was fraudulently acquired just days before Sharon's murder, coupled with the second accused's insistence that the line be used as the exclusive channel of communication between Sharon, PW9, and PW28, the only two people who had become Sharon's close associates, leads me to an irresistible inference that this line was acquired as part of acts of preparation for commission of the offense. Regarding the events of that September 2018, which needless to state is the date that Sharon was abducted and subsequently killed, the prosecution led evidence seeking to prove that there was a preparatory meeting held at the third accused's wife's home, that is Olivia's home, in the morning. PW38 testified that he found the third accused seated outside the home in an apparent meeting with one Dicky, Olivia, with one Dicky. Olivia and Elvis were inside the house. PW38 had gone to the house to pick a copy of the subject vehicle's logbook to facilitate its valuation. In his evidence under cross-examination, PW38 clarified that he had confused the time that he had gone to the home, that it must have been after 12 or 3 p.m. since he went to the home after talking to Olivia. The second and third accused denied having attended any such meeting, claiming that they did not leave their places of work on that day. At the cross-examination, however, the third accused recalled that in his statement to the police, he had actually admitted that he was at Olivia's home on that day around midday. Although the second accused claimed that on that day he was busy in his office preparing for an official trip to Rwanda on the following day, the email correspondence from the travel agent, which he produced as the defense exhibit 4, indicated that as late as 12:59 p.m., his ticket to Rwanda had not been confirmed, as it was still on the waiting list. Elvis, who testified as defense witness 4, also denied having been present at Olivia's home at the time alleged. I must state that in my assessment, I found Elvis all Evi struck me as an untruthful witness, considering that he claimed in his evidence that he did not know Sharon or her relationship with the first accused, despite the fact that there was evidence which he admitted that he had been one of the first accused bodyguards and had worked in that capacity for 10 years. In the circumstances, he claimed that he was not aware of that relationship was implausible and can only mean he cannot be taken to have been a credible witness. I therefore do not give any weight to his claim, to his evidence. Continuing with evidence adduced relating to the events of that September 2018, the prosecution also tendered evidence through the evidence of PW9 and PW13, not 13, PW38, to prove that the second accused convened a meeting with Sharon and PW9 at Gracia Hotel in the evening. This meeting, as noted earlier, was acknowledged by the second accused in his evidence, and he admitted having met Sharon and PW9 in that hotel to deliver a message from the first accused. There is also evidence which was also admitted by the second accused that he left this hotel together with Sharon and PW9, and although there was conflicting evidence between the evidence given by PW9 and PW38 regarding the manner in which these two witnesses, Sharon and PW9, together with the second accused, left the hotel. There is evidence that PW9 and Sharon boarded the vehicle that was being driven by PW38. Whereas there is, according to PW9, the second accused also boarded the same vehicle. There is evidence that this is the vehicle in which the second accused, Sharon and PW9 were allegedly kidnapped, and the vehicle that and it is this vehicle that transported the late Sharon to the scene in which she was subsequently killed. I have noted the discrepancy between PW9's and PW38's evidence regarding whether or not the second accused boarded the subject motor vehicle. In my mind, while the accounts of PW9 and PW38 differ on the precise sequence of how they left the scene, they converge on the critical point that on the 3rd of September 2018, the second was with the deceased NPW9 at Grasha Hotel in the company of unidentified men